Thank you for coming. Appreciate all of you being here. This is the Judiciary Committee and our meeting today. We got several bills. We're going to get to them and talk about them. Before we get going, I want y'all to understand there are three of these bills that we are carrying over at the request of the sponsor. One of them is House Bill 426 we are carrying over. House Bill 426, House Bill 173, and House Bill 174. So we're carrying those three over, but the rest of them I feel like we will be able to get to with no problem. I've been out for the last 3 weeks. Let me assure you that all of you look good to me today. All of you look good to me. I'm delighted to be back here, so thank you. So, Brandy, if you would, call the roll and let's get going.
Hill.
Here.
Wadsworth. England. Bedsole. Brinyard. Chestnut.
Here.
Faulkner. Here. McClammy. Pettis. Robbins. Here. Robertson. Simpson. Starnes. Stringer. Tillman. We have a quorum.
It's a pleasure to be back. We've just now eliminated 3 of our potential questioners, but we will go forward. Yeah, go Dogs. That's it. All right. How about Senate Bill 83? Senator Orr? Is anybody carrying this for him?
Judge.
Yes, sir.
Chairman, welcome back, and also to my colleague sitting next to me, Matt Simpson. Really great to have you back, brother. Judge, this is the bill, that ALI bill that we've already passed. It's the exact same based on the amendment, so I would move to give it a favorable report.
Thank you. I appreciate it. I appreciate it. Is all in favor of that? Please say aye. Aye. Thank you. Thanks, Mr. Faulkner. That speeds up the process. How about Senate Bill 272? Senator Orr? Okay.
Almost, not quite, Senator Orr. Thank you, Mr. Chairman and committee.
You are a considerable improvement site-wise over Senator Orr.
Thank you very much. I'll be sure and tell him you said so.
He knows.
SB 272 has to do with Open Records Act. We've got some problems with that in the information that is being requested. People are able to use that for wire fraud, so that's the first section that is in the bill to change. The wire fraud protection requires custodians of public records to redact sensitive financial and personal information from public record requests when the information could be used for fraudulent wire transfers. The second thing is the solicitation protection, which prohibits anyone who obtains that personal information through a public record request from using that data to solicit individuals or entities for sales and services.
Is there amendment to
Yes,
this
sir, there is.
bill? Is there not amendment?
Yes, sir, Mr.
All right, Mr.
Chairman.
Brinyard, would you tell us about the amendment?
Yes, sir. It literally just takes out the words local board of education in lines 20 through 21, so that it would read like this. Contract for goods or services are requested pursuant to Article 3 of Chapter 12 of. So it just takes out local board of education.
Okay, and that amendment has been offered. Is there a second? Thank you. Are there any questions for Representative Brinyard just concerning the amendment? Seeing none, all in favor of adopting the amendment, please say aye. The amendment's adopted. Representative Holt-Jones, we are back to you with Senate Bill 272 as amended. Anything else?
No, sir.
All right. Do I hear a motion to give Senate Bill 272 as amended a favorable report? Yes, sir. Thank you, Mr. Robertson. Second. Are there any more questions on it? Seeing none, all in favor say aye. Any opposed? Thank you, ma'am.
Thank you, committee.
What about Senate Bill 273?
I'm going to carry it,
Okay, thank you.
and I'll do it from here. It won't take but a second. What the bill does, it basically makes a second offense for second or subsequent violation of this stalking a Class C felony.
Okay.
That's all it does.
All right. There's a motion. Is there a second? There's a motion and a second for a favorable report. Are there any other questions or discussions? Seeing none, all that want to give this bill a favorable report as amended, please say aye.
Aye.
Any opposed? All right, no, it's not amended, it's just a favorable report. Thank you. Favorable report. Senator Barfoot, you want to go 240, I mean?
Yes, sir, Mr. Chairman. Good to see y'all. Glad to have you back and Representative Simpson. Appreciate the opportunity to be here. If I could, I'll explain the bill. Members of the committee, y'all have seen this bill, I think, in some form or fashion over the past 3, maybe even 4 years now. The old statement about the third time's the charm, maybe the fourth or fifth time's the charm, I hope. I think it's gotten out of here, if I remember correctly, most of the time, if not all of the time. This bill essentially is an agreed upon bill, and I want to publicly thank the members of Vocal who are here today, working with them. They've gotten some success stories that I'm sure they'll be sharing with you individually about how individual family members and victims from as far away as Kenya, I believe, would be able to participate in these virtual parole hearings. It simply allows an inmate who is up for parole the ability to either phone in or do some type of, I'll call it generally Zoom, with the Board of Pardons and Parole when their term comes up to be reviewed. It also allows the victims' families, anybody who's speaking on behalf of the victim, to do the same. So it gives more information to the parole board to consider. As you know, lawyers especially, whenever you're in a courtroom before a judge sentences someone, they will typically say to the defendant, do you have anything to add to me or say before the court imposes a sentence? I think this is analogous to that. It's important that three-member board have all the information in front of them, including the demeanor and what that inmate may say. Over the past couple of years, there has been some discussion about the need for extra funding on that. I would say to you that if you look at the fiscal note on this, and I hope you have it in your packet, the fiscal note on that would be a whopping $48,000 for an initial setup and $34,000 annually after that. So it's not a stretch for DOC and from a financial situation. So I'd urge you to consider that as well as the final passage of this bill. I'll be happy to take any questions.
Is there amendment to this bill? Please, go ahead, sir.
Senator, let me first start off saying I apologize. You and I just spoke about this and sincerely apologize for the tardiness of the communication. But the amendment I have does kind of hit at the heart of what you just spoke on, and with the fiscal note in mind. So simply I'll explain. This will be on page 2, line 44. Paren E, replace line 44 on page 2 with the following paren E, contingent upon the appropriation of funds by the legislature for the purpose the Department of Corrections shall procure a. And then the second part of the amendment on page 2, line 51, replace in lieu of and have this language, board in the implementation of this act, and then paren F, all implementation, orientation, and maintenance costs associated with the implementation of this act shall be shared between the Department of Corrections and Pardons and Board of Pardons and Parole. Simply, that'll be the appropriation of funds and then the shared cost between these two entities to execute this video service.
Senator, back to you.
So Representative Bedsole, we get busy around here and there's no issue with that, and we've always worked well together. I would just say I don't think finances are an issue with this. You heard the fiscal note on that, and I would humbly ask this committee to vote against that amendment.
Okay, there's a motion before this committee. Is there a motion to lay this bill this amendment on the table?
So moved.
Okay.
Second.
Second. There's a motion second to lay it on the table. All in favor say aye. Aye. Any opposed? Okay, it laid on the table. So Senator Barfoot, it's back to you unamended. Go ahead. Mr. England.
Move to give a bill a favorable report.
All right. Yes, sir. Sir, go ahead, Mr. Starnes.
Senator Barfoot, I have one concern, and I just want to see if you can address this. With the victims, I had my ex-father-in-law was killed in a drunk driving accident. He was killed. And the family would go to the parole board and speak up against him getting parole. And he was denied parole each and every time. Now, if the victims are relying on the system and there's technical difficulties for the victim to speak up, what's the mechanism to protect? Because I know the parole board may just say, you know, disregard that technical difficulty and things and let's move forward. But I'm concerned about the victim on that part. And I know you've got the victims for that, but I just want to ensure that that's taken care of, and that's something I'm concerned about. That's the only thing.
Yes, sir. If I could,
sir,
Mr.
please
Chairman. You're right to be concerned about the victim. Far too often, we're not as concerned as we should be. And this bill specifically says if the communication system fails or is any way interrupted during a hearing, the board shall suspend the hearing until the communication is reestablished. So as a victim or a family member of a victim or a representative of a victim, they still have the option, number one, of being there. And number two, I think greater participation, because you've got victims all across the state who may have to drive 3-4 hours, sometimes, by the way, out of state or out of country, like we've just talked about, that have that ability now to have their voices heard by electronic means. And so I think this bill addresses that it would be suspended until the hearing, until the communication is reestablished.
Yes, sir. Thank you.
Thank you.
Mr. Tillman, did you have a question? Sir? Oh, you second the motion. Thank you. And Mr. Faulkner, did you have a question?
Yes, sir. Mr. Chairman.
Yes, sir.
I see some of my vocal friends here, and I know this was just touched on, but I want to make sure you said vocal is in support of the bill and have worked with you on this and they're not opposing this bill, maybe is the better way to say?
Can I, so Mr. Chairman, if
Sure.
I could, let me address that. So
sir.
I would ask that you recognize their nods, either yes, that they're for it, and I would say yes, that they are not only not against it and okay with it, but I believe that they are for it.
Okay.
So
All right.
if I'm wrong, somebody raise their hand.
I will take you at your word, hearing nobody shouting.
I'm going to tell you what, Senator Barfield, if you make that a proffer, the court will accept that proffer.
Thank you.
All right, ladies and gentlemen, we got a motion and a second to give this bill a favorable report. Any other questions or discussion? All in favor, please say aye. Aye. Any opposed? Senator Barfield, thank you a lot. You got a favorable report.
Thank you, Mr. Chairman. Thank you, committee members.
Senator Albritton, how about Senate Bill 87?
Good afternoon. Thank you for having me and having my bill up. This bill takes care of a liability issue, if I may say it that way. Real estate appraisers right now, when they do work, they make the appraisal of properties for loans and purchases and constructions. And after they turn that report in to the lender, typically, they remain liable for that forever and ever, amen. There is no statute of limitations on that. I put myself through law school doing real estate appraisals, and to the best of my knowledge, I'm still liable for the house I did back in 1989 or whatever it was, all right? So what we're trying to do, like most other professions, is put a statute of limitations from a time frame of civil liability. That is a 3-year time frame from the time of discovery of the issue, but no longer than 5 years. So it's a maximum of 5 years from the date of the appraisal or 3 years from the date of discovery. It also puts this in and makes it the question that the real estate authority board was that we don't change up the time frame of activities of errors and such or problems, so that they have up to 5 years, and that's the codification of their standard policy that they've had for years, to look back and to take a real estate appraiser that's made an error or a mistake or nefarious and take them before the board for disciplinary action. So that's all been approved. That's the bill.
Okay. Any questions? Yes, sir, Mr. Robbins.
Hi, Senator. I was just reading the bill, and I think there might be a typo that we might need to address, that on line 40, it says levy fines as provided in subsection C. But see, now with the addition, D has the fine, the administrative fine on line, so 119 is section D, and it's showing where you can levy the administrative fine. So it says, so where it says on page 4, on line 40, subsection C, and C now is dealing with disciplinary proceeding based upon a civil judgment, where D, I think it was C. As you can see, they struck through C, and I don't know if LSA can correct that, or if we need to amend it just to.
Obviously, I don't know how long you've been in the legislature, sir, but you should know that there's a hidden rule that we are not supposed to read bills. No, thank you. On that technical aspect, look, I'll rely on LSA to discover, and I'll bring those to their attention. But I would like to get this passed out so that we could have them review this, and then if there's any technical errors and such, we can get those corrected by amendment before you bring it to the floor.
Well, that was my question. Could we just amend it right now to correct it?
Well, I'm not certain. I'd like to get LSA's take on that and the Scribner to find out for sure if that's.
Right. I mean, we could do it right now if you're okay with that, Senator.
That'd be welcoming as a friendly amendment. I wouldn't have any problem with that.
Okay.
So do you offer that?
I mean, I love it when LSA admits a problem.
You're just changing C to D.
Right.
All right. Is there any questions? Is there a second on that? Thank you. Any questions? So all we're doing is just changing the numbers or the letters so that they match up.
Exactly. It's a very technical issue.
Yep. All right. All in favor of that amendment, please say aye. Aye. Any opposed? It's adopted. Okay, Senator.
Good
back
catch.
To you as amended. You okay?
Say again?
You're back to you as amended. Anything else?
No, sir. If there's no other questions, I'd like to have to go on through as amended.
Yes, sir. Is there a motion to?
I'll make a motion as to favor report as amended.
Favorable report as amended. Is there a second? Second. All right. All in favor of the favorable report as amended, please say aye.
Aye.
Any opposed? Senator, thanks. Appreciate it.
Thank y'all. Appreciate your patience.
Thank you very much.
Thank you.
426 is the next one. We are carrying that bill over. Pursuant, Chairman Lee asked us to carry that over. We're going to do so. Ms. Hall, you want to do House Bill 437?
Mr. Chairman, it's good to see you and Mr. Simpson. Thank you very much for the opportunity to present House Bill 47. House Bill 47 amends how the Alabama Board of Pardons and Parole will make a decision about granting, denying, or revoking a parole. It also gives the board more explicit discretion to consider the totality of circumstance when reviewing parole violations. And the third thing is that it would adjust the procedures and penalties related to parole violation, including when a parole can be revoked and how sanctions can be imposed. And this is what the bill is about. I will indicate, Mr. Chair and members, I have met with the different groups that would have concerns about this bill, and I feel that at the appropriate time we do have an amendment.
Okay. Who's got the amendment?
I do, Mr. Chairman.
Okay, thank you. Go ahead.
So I think it's you have the amendment in front of you. My understanding is this will match up Representative Hall's bill with the Senate version of the bill. And before us, is this the Senate bill before us or Ms. Hall's?
No, it's Ms. Hall's.
Okay, so I think that's what this is doing, is matching up the bills. This is the explanation of the amendment, and certainly Representative Hall can add to this, but it requires the parole court to be reasonably satisfied that a parolee committed the offense when a new arrest is the basis of a parole violation. It ensures that if an individual's parole is revoked due to a new charge and the individual is later found to be not guilty of the charge, the board may set a new parole hearing to determine whether the individual is again suitable for parole. Maintains that individuals on parole who were convicted of certain enumerated offenses are automatically revoked if they were charged with any new offense or commit a technical violation. And I think that's the bulk of it.
Yes.
Yes. So I would offer the amendment that is before the members, Mr. Chairman.
Thank you. Is there a second? to
Second the amendment.
Second. Thank you, ma'am. All right, there's a motion and a second to adopt this amendment. All in favor of that, please. Are there any questions on the amendment? Seeing none, all in favor, please say aye.
Aye.
Any opposed? Okay, it's adopted. All right, Mr. Hall, this is back to you as amended. Is there anything
I
else?
would ask a favorable report.
All right, Mr. Pettis.
Ms. Hall, Attorney General's office contacted me, and they said they're
Really?
not in support of this bill, the way it's written. They said they'd talked to you, and they just couldn't get eye to eye with you.
And so you're right. I had a meeting with the Attorney General's office, but what I will tell you about this bill, the statement that was made was that they felt that the rules were in place to do this. It is my belief that if you take this amendment and this bill, that would make it appropriate that you could, because the pardons and parole also indicated there was a problem that needed to be addressed. So that's why we're here. Everyone that was the AG's office is the only office did not come back to me, and so I did. They were in the meeting with me, and they expressed their concerns. So I'm not saying that you're lying about that. So, but I would ask you to please pass this bill.
Okay.
Mr. Paul,
Thank you.
You had a question or a comment, either one?
Yes. Ms. Hall, when we reviewed this, and I had my notes, and I've gotten someone else's binder from our review, but it was the amendment that I would ask that you would work with me on is to allow the time. There was an immediate reinstatement of parole or a and I wish, unfortunately, I don't have my binder that had my notes, but it was what we were trying to do there is instead of an immediate reinstatement was to make sure that if there was once the time for appeal had ended, you would then have a reinstatement. In another place, I think it was like 30 days. But what we want to do was say that you would have to the time when the appeal had ended, pursuant to the rules of criminal procedure, then you could have the immediate, because the words in here were in immediate, and I'm okay. I'm sorry. Here it is on page 8. And if you read on there, on line 200, in all cases where the basis of the parole revocation is a new arrest for which charges are later dismissed, result in an acquittal. We wanted, in that circumstance, not when they've been resolved as a criminal violation, that instead of saying the board may either immediately reinstate parole or the parolee shall be immediately eligible for parole, we want to state that the board could do that after the time for an appeal has run. And we're trying to give that the time period for a prosecutor to file an appeal. And so, but I'm willing to work with you on that, after today. I'm not trying to do this to hold up your bill.
Really? Do you mind, Mr. Chair, allowing Ms. Birdsall to speak to that?
Oh, ma'am, I certainly
Thank
don't.
you.
Thank you, Mr. Chairman, committee members. Representative Faulkner, I think the issue you're expressing was in the original bill, but the amendment actually covers that. Does that answer your question?
I was wondering that.
Yeah.
when I saw that.
Yes, and
Okay.
Katie is here as well. If there are questions about that amendment was from the district attorneys, and she could
all
answer
right.
it more specifically.
This came up totally separate from my talks with DAs, so I was wondering if that amendment covered it. So I appreciate that. And
Yes, sir.
Katie, that jives.
Yes, that was one of our major concerns as well. And so when drafting this amendment, that is something that we corrected with the help of Representative Hall and working with the other people.
Appreciate that. Thank you, Representative Hall.
So OPS is good with this amendment, is that what you're telling me?
Yes, the DAs, after reviewing the original bill and then working through the amendment, voted to support the bill as amended. So the DAs actually support this bill as amended.
Thank you, ma'am. I appreciate that. Mr. Tillman,
Judge, at the appropriate time, I move for a favorable report.
as amended.
As amended.
All right, there's a motion for a favorable report as amended. Yes, ma'am, please. We got it. There's a motion for a favorable report as amended. Any questions? Yes, sir.
I have a request that we sit down with the Attorney General's office since they are still impose this bill and put it subcommittee and have the Attorney General's office work with their committee next week and bring it back, have it ready to bring back up next week. If we can do that.
I got a motion and a second to give this bill a favorable report. I think that takes precedent. All right. Okay, all in favor of favorable report as amended, please say aye.
Aye.
Any opposed?
Nay.
All right, that's favorable report is amended. Thank you, Ms. Hall.
Thank you.
Ms. Hall, what I would ask, if there is a question with the Attorney General's office, which I feel like the OPS is okay with it, generally those two entities work in lockstep. It's been my experience over the last 12 years. But I would ask that you get with them, and let's make sure.
I have no problem, Mr. Chair. I met with all of the groups together, and I have no problem, and my door is always open to hear what their concerns are. Thank you.
Ms. Hall, I'm well aware of that, and we appreciate you. We do. Okay, HB 503.
To this august body, this chairman of this committee, I am State Representative Gavan, and before you, you have, or you should have, 503, and thank you. And there is an amendment by trial that I have also, Mr. Chairman, at the appropriate time.
Who has the amendment? Mr. Ingram, please go ahead.
The amendment, what it does on line 33 on page 2, it replaces line 32 on page 2 with the following: by law or civil proceedings. So it basically adds the words "or civil proceedings."
Thank you. Is there a second to that amendment? Thank you. Motion and second. All in favor of that amendment, please say aye. Aye. Any opposed? Okay, Ms. Gavan, I guess we're back to you with your bill as amended.
Thank you, sir. This bill would prohibit the disclosure and transmittal of crime scene images. That means the sale and distribution thereof, unless used by law enforcement, prosecutorial teams, or what have you, and anyone in violation of this penalty could possibly face the violation of, or is found guilty of, a Class B misdemeanor.
Okay.
I did not know we did not have anything in place for this, and I know we're moving about with a lot of bills that you're working on regarding IA and dealing with these issues, but I think this is a good first step, and I have consulted with trial over this, and of course, Representative England has just read their amendment, and I'll hear any questions
Got a
or any
motion for
concerns.
favorable report. You got a question, Mr. Robbins? Go ahead.
Hey, Representative Gavan, how are you?
I'm great, thank you. How are you?
I'm good. I was reading the bill, and I'm not opposed to the bill, but I was kind of wondering, had you thought about giving the estate a right of action against the individual that took the picture, as opposed to making a crime, letting the estate sue the person for disseminating the image?
No, I really hadn't thought about that, because I would think that they would be able to take those necessary steps and actions because it would be considered a crime. And so therefore law enforcement would already be at play. I didn't think about it from that standpoint, but I just wanted to put something in place because there's so much going on out here these days, and especially now with modern technology and other issues that are arising, and especially because of AI and some other things, I just think we need to put some safeguards in place with regards to crime scene photos. We ran into an issue a few years ago with dealing with body parts and things of that nature. In some of the various jurisdictions, and I didn't know until then that we didn't have anything in place with regards to crime scene photos. Someone could be terminated, of course, but no criminal penalties.
There is a motion to give this bill a favorable report as amended. I need a second.
And if you wanted to add an amendment, that's fine, but as far as I was concerned, I thought the penalty hopefully would be a deterrent.
Anything else, Ben? All right, there's a motion to give this bill a favorable report as amended. If there are any more questions? Seeing none, all in favor say aye. Any opposed? Thank you, ma'am. Favorable report is amended, and now you got the next one, 293.
This bill, and I do know there are going to be a package that other legislators are possibly moving forward with. We as legislators and elected officials, not just legislators, we take a lot of harassment, a lot of harassing communication, and so this bill would just further amend the code to add that classification within the code and making it a Class B misdemeanor if you are found guilty of such harassment of us as elected officials or what have you. I think it's pretty self-explanatory.
Okay. Thank you, ma'am. All right. I see no amendment to this bill. Is there a motion to give HB 293 a favorable report? So moved. Is there a second? Thank you. About a motion and a second. All in favor of giving HB 293 a favorable report, please say aye. Any opposed?
Nay.
Thank you, ma'am. Appreciate you very much.
Thank you.
HB 505, Representative Bolton.
Thank you, Mr. Chairman, committee. HB 505 will amend sections 151643, 151661, and 151670 of the Code of Alabama to allow for an appeal by the Department of Mental Health to the Court of Civil Appeals upon a denial that they've approved for release of a defendant that's been in their custody.
Okay. All right, now, wait a minute. Hold it. Are there any questions? Yes, sir, Mr. England.
Okay. I guess one of the questions that I have would be, what would be the standard of review? What would be the standard of review in terms of if you get an appeal? Is it abuse of discretion? I mean, what would be the standard?
The standard of review for the mental health department approving the person for release, or the standard of review that the courts will use to judge whether or not it's appropriate?
Well, I think I kind of jumped the gun because I think Representative Simpson just pointed out to me that the amendment that's on the bill would put the standard of review as abuse of discretion.
Oh, that's correct. I'm sorry.
I'm going to be honest with you. I never knew that there wasn't an appeal for this decision.
You're like me. I did not either.
And I think, and I do understand what you're doing.
I understand.
But what I'm concerned about is, you've got a judge with the original jurisdiction who has made a decision about whether or not someone needs to remain in, I guess, secure custody.
Yes, sir.
And having the department having the ability to do a very cursory presentation to the judge and then appealing that decision to the Court of Civil Appeals. I think that's where it goes, right? Court of Criminal Appeals,
Yeah, that would be criminal appeals, I'm sorry.
Which would be judges that are not from the area and are not familiar with maybe the person themselves or the facts or what happened, and we get a different presentation because the purpose of the department doesn't agree with the assessment that the original judge made.
Yes, sir.
And they're going to use the appeal just to get around that initial assessment.
I understand.
And that is what really concerns me.
Yes, sir.
Because I know, unfortunately, not all employees that have worked in the Department of Mental Health have shared the same vision about public safety, infrastructure, bed space, resources, and the like. And I have been party to situations where the decision of whether or not to house someone in a particular facility wasn't necessarily as much based on public safety, but more so on resources, which means that a judge who assesses this case, who assesses this individual, and makes that determination initially that says that this person is entirely too dangerous to be released or to go to a community-based placement or whatever, this would give the department the ability to circumvent that and possibly place somebody that the community does not want out. And I would much rather have somebody who's closer to the ground, who knows the facts, knows the circumstances, knows the parties involved, to have more dominion over that decision than judges who are in Montgomery who really don't know a lot about what happened. And when you do an argument about the standard of review being abuse of discretion doesn't necessarily, it's not fact-based at that point. That's a legal standard that we're arguing about whether or not the judge has the ability to make the decision and not necessarily the merits of it. So for me, I'm going to struggle. That's where I'm struggling.
Yes, sir, I understand.
But I do understand what you're trying to.
My purpose in accepting this bill for presentation at their request was to provide, originally, and as it's written in the original bill, we're going to come with an amendment that takes part of that out, but was to provide the same type of appeal process available to a patient that's been cleared that I would have if I was a criminal defendant in any other setting.
Yeah. That's all I have.
Go ahead. Is there, before I do this, Mr. Simpson, let me ask you, isn't there an amendment? Mr. Starnes, how about, let's go over the amendment. Let's get us in a position where we can talk about it fully.
Yes, sir. Replace line 13 on page 1 with the following. Department for orders committing the. Replace line 30 on page 2 with the following. Of mental health regarding orders of. Replace line 58 on page 3 with the following. The Department of Mental Health. Replace line 60 on page 3 with the following. Orders for abuse of discretion. Replace line 63 on page 3 with the following. The defendant. Replace lines 105 through 106 on page 4 with the following. The department may appeal to the Court of Criminal Appeals the following orders for abuse of discretion.
Thank you. And what this does, this simply removes the independent ability of the defendant to appeal and puts it back on the Department of Mental Health.
Mr. Chairman, I have
Is that bill, that amendment has been offered? Is there a second?
a comment on this amendment.
All right, but let's get a second on it, then I'll let you. Is there a second? Thank you. I got a motion and a second on the amendment. Mr. Simpson, go ahead on the amendment.
I'm going to stick to the amendment, but I also want to echo 100% what my colleague, Representative England, mentioned about taking the judge away from the factual judge at the basis,
yes,
away from the decision to go through this. My issue with your amendment is you remove the defendant from being able to appeal this process. Part of my problem with the bill and why I will be heavily opposed to this bill is there is no mechanism whatsoever for the state to appeal this issue.
That's correct.
So if a judge makes the determination that this person is free and willing to, and has the ability to go out, the state can't appeal and say, hey, no, this person's dangerous to go through it. The only appellate process you have is the Department of Mental Health. You've taken the defendant's right to appeal out through this as well. This becomes a concern of Are we just putting people, and I've seen too many cases. I've argued too many cases and done too many of these hearings where I've seen people that are released because the Department of Mental Health, I'm not blaming the Department of Mental Health. Please understand, I love the Department of Mental Health, but there are doctors that will do things and say things because there's a bed may or may not be available. And if they can move somebody out of here without a bed, then they make the decision based on not necessarily what's good for the public, but what's good for the bottom line on some of these issues. And I've had those cases. I've argued against doctors. I've argued against the Department of Mental Health to go there. I've had cases. I haven't specifically had them, but I know in Mobile County, we've had cases where the Department of Mental Health has sent somebody out from, custody and put them into a home. And in the home, they've committed another murder while they're there. There's too many instances of dangers that's been through the community where you're not allowing the DAs to appeal this, you're not allowing the defendant to appeal this, you're just letting the Department of Mental Health say, we don't want to pay for this person to be here. Under this bill, they can say, we don't want to pay for this person to be here. They should be free to go out. And if the judge says, no, I've seen the facts, no, I've seen the pictures, no, I've heard from the family, no, I've heard from the prosecution, no, I've heard from law enforcement, you have this as a document that the judges, I love the Court of Criminal Appeals as well, but they're not going to have the full inflection of what happened in that courtroom when they make this decision. And I really, really am strongly opposed to this bill.
I understand. The language where we moved the defendant's right to appeal was worked out with the Office of Prosecutor Services and a couple of other statements. Now, the one thing we did not agree on was the state's right to appeal, because typically when you have a defendant, in a criminal trial, the state has no right to appeal acquittal there unless they've got some kind of new evidence or something.
But this has nothing to do with the guilt versus innocence phase of it. This has everything to do with the custody and how that person will be treated through the process and the penalty, or the lack of a penalty if you're in GRI, of how that person will be considered to be in custody of the state. I understand not appealing the determination of the jury, but we're talking about where that person would be positioned.
Yes, sir. Thank you.
All right, we got a motion over this. Roberts, you have a question or either one?
I just have a comment. I think I need to point out that I want to make sure, so Representative Simpson, you're okay, right? You came back and you and Representative England are like on the same page, arguing together. I just want to make sure that you're 100% and not some,
I tell Representative England all the time, we're dangerous when we agree on an issue. When we're on the same page on something, there's some legitimacy to it. I've been told that committee meetings have been very pleasant for the past 3 or 4 weeks, that no drama, no controversy, and I just came to change that a little bit up today.
Well, thank you.
You're world class at it. Do what? I said you're just back too. Yeah, I know it. It's a pleasure to be able to ride herd over them agreeing. I'm very uncomfortable in that situation.
Quick comment.
Yes, sir. You may. Sure, Mr. Bessel.
Mr. Chairman, seems like even the protest from Representative England and Simpson, there's pieces of this that maybe could work through to get to it, because I think all of us had a realization that right of appeal wasn't there.
Right.
I know we've had a motion already, but if perhaps, Mr. Chairman, you entertain a motion for a subcommittee to try to work through this. I don't know if the two gentlemen behind me would be agreeable to be a part of that, but it sounds like this is something that could be beneficial.
I'm fine with either way y'all want to go.
Agree with that.
I'd like to be able to move it.
Criminal subcommittee. And I'd like for Mr. England and Mr. Simpson to work on this. All right.
I wasn't trying to give myself any more work, but at the same time, I do feel very special right now that Representative Simpson, in his recovery, has come to the light.
I wouldn't go that far, but
I do. Can I?
Either one of you.
But do you want to not even worry about adopting the amendment?
Oh, so I'm just going to send this to a criminal subcommittee. Thank you, Mr. Bolton.
But before, just
please.
But also, at the same time, with this legislation, there's several other components to it that we've been dealing with, and I think most of the state of Alabama is probably dealing with a significant crisis of lack of resources all over the state.
That's correct.
I live in Tuscaloosa, and Tuscaloosa houses most of the only facilities that we have left. One of those is Taylor Hardin.
Right.
And to that end, part of this legislation is in pursuit of a lawsuit that, you know, the Department of Mental Health is under some pressure in terms of how long people have been
there's
committed.
a separate bill addressing that.
But it's all part of a bigger package, and there's a lawsuit dealing with the fact that people have been who are not guilty by reason of mental disease or defect who have been in facilities too long, and I understand that, and I definitely see that issue. But what I want to make sure is that everybody has, in these cases, have to remain a willing stakeholder, a willing partner, doing whatever's necessary to find placements for people. Taylor Hardin, as a result of some of these things, in additional appropriation, the Department of Mental Health will be expanding to adding 96 beds. And that's vital for Tuscaloosa County because, you know, with Bryce Hospital and Taylor Hardin, you know, if those are the only places in the state of Alabama where people can go, without that infrastructure, you know where people end up.
For sure.
So, again, I do understand what you're trying to do, and I don't like the fact that people who don't need to be there are probably there longer than they're supposed to be. But there's got to be a way to draw some sort of happy medium between the two to make sure that people we don't want out don't get out.
Okay. Would you and Representative Simpson be willing to work with us between now and the floor to try to make it tenable for you? Or I know that you're going to want to.
We'll put it in subcommittee and we'll work on it in
subcommittee. I think
work to
that.
that.
Mr. Faulkner, you had a question?
Yeah, but are we just put it in subcommittee to kill it? That's my question to you.
No, sir.
Okay.
No, sir. We don't. We do not put things in subcommittee to kill them.
Okay.
I think I'm fairly well known for that.
Okay,
Go ahead,
thank you.
Mr. Faulkner.
Thank you, Mr. Chairman. Representative Bolton and I had met with Department of Mental Health, and I'm echoing what Representative England was saying about the need and why this bill is being brought and why you're bringing it.
Yes, sir.
And so I'm in support of that. I realize that I have colleagues that want to work out some issues, but I echo what Representative England is saying is that there is a need for this, and the bill and the concept and the reason it's being brought, you know, so that there is this process of appeal to the Court of Criminal Appeals.
Yes, sir.
And so I just echo that part of this. That,
I understand.
And no, Bill's here, Chairman's been very clear since he's been our chairman. They don't go to subcommittees to die. He usually has them up the next week. So.
That's great. And I'm good to work with anybody on anything in relation to Representative England. He and I are working together on these exact issues in the city of Tuscaloosa right now because we've got a large problem in downtown Tuscaloosa, and we're trying to figure out how to resolve this as it relates to homeless problems also and problems in the business community there. So this did kind of hit home with the city there.
All right, sir, and I appreciate that.
Absolutely, thank you, Judge.
I think we should work. What I'm going to ask y'all to do. Let's work on what standard the appeal should take, because you know, if you appeal a case now, as both of you know, the standard is. That the case heard from a judge is due to be granted. There's an ore tennis rule that we all know about that is a very strong rule that favors the ruling of the judge. And maybe we need to work something of that nature into this type of a situation, because I understand what both of you are saying. Thank you. We're going to carry it over, but no,
yes,
Mr. Bolton, it does not go there to die.
Thank you,
That's
Judge.
not the obvious.
I appreciate it.
Never has been.
Thank you.
Criminal. 10 o'clock next Wednesday. It is. Okay, Mr. England, how about 481? On that bill, I'd also like OPS to be involved, because I think we, you know, I really do understand what they're both saying about Taylor Hardin, because I've had those hearings. I do understand what Mr. England and Mr. Simpson are saying, because I've heard them too. I got you. And I'd like for OPS to certainly have some input. I certainly, though, also, I want to make sure that the department gets a hearing that is an appeal. I believe in appeals. I think every judge needs to be overviewed. I have no problem with appeals. Thank y'all. Mr. England, 481.
Thank you for the opportunity to present House Bill 481, and it's a really simple bill in its execution, but I understand it's probably complicated and practically when it comes to court funding. But over the course of the last, say, 10 to 15 years, the victims in court cases and restitution have become less and less of a priority, to the point now, before a victim gets any restitution, the court costs and everything else are generally paid first. So what this bill would do would put the victim in the front of that line. So when the defendant makes payments to the court costs, that money goes to restitution first. And that's essentially what the bill does.
Okay. And you offering that, you're asking for a favorable report, is that correct?
Yes, sir.
Is there a second? All right, well, let's get a second. Is there a second? Thank you, Mr. Tillman. Okay, Mr. Robbins.
Representative England, thank you for standing up and walking up there. Makes it very professional there. But I had two questions or two thoughts. In reading it, where it says on line 102, 103 there, it says, the order of restitution shall be enforceable as if the order were a civil judgment and shall be paid and collected before all fines, court costs, and other fees imposed by the court. So if we would treat it like a civil judgment, would we allow that restitution to be recorded in a probate office? Because you can record an order and a judgment. You can record a judgment in the probate office. So there, if you're doing a title search and let's say you see that John Doe is trying to get a mortgage, you don't look through the criminal records, you don't look through the circuit clerk's office, but you would look in the probate office. So if we're treating it like a civil judgment, I'm saying, would you allow it to where it could be recorded? And so then if that person's ever trying to use property or anything as collateral, it would show up in a title search and they'd say, well, you got to pay that before you can even get a mortgage.
I believe that's part of the reasoning behind that, to not only make it first in whatever court costs are imposed, but to also make it where if someone else is going to make it possible to retain or to get that restitution in other measures as well.
Yeah, I mean, I agree. I guess if it is a civil judgment, you could record it. So, I mean, that would allow you the authority to do that. But then on line 40, I don't have a problem with the second part of this sentence, but it says, it is the intent of the legislature that no other debt owed by a criminal defendant be satisfied before the restitution to the victim is first satisfied. So that phrase, no other debt, and the second part of that is, it says, with that criminal conviction, where that first sentence says that no other debt. So it's not tying it just to the debt of the criminal conviction. It's saying no other debt. So if you do have a mortgage, a lien, you're saying, well, sorry, bank, I had to pay this debt before I could pay my mortgage because the legislature has the intent that, I have to pay my restitution before I pay any other debt.
That particular section deals with only criminal convictions. So,
right. I mean, it does,
the way that it's written is specific to a court order from a judge for a restitution order.
Right. I know no one's going to go digging through this code section and pull that out, but I was just kind of wondering the wording there and why. And if we wanted to say, because I like the second part of that. I like that second sentence where the legislature declares an order of restitution shall have priority over basically everything associated with that criminal conviction. I think is what you're trying to say instead of having the two sentences.
Well, and I can just, plainly tell you that the reason why it's written specifically as it is because it hasn't mattered in the past how it's been written. We've always found a way to set the victim aside and pay, quite frankly, everybody else. So the reason that the intent language is there to specify, so there is no question in the future that when a defendant is required and ordered by the court to pay any money to the court, that restitution is satisfied before anything else. And quite honestly, the reason that we're here isn't necessarily because of a statute, it's because of several Attorney General's opinions, and then in 2011, a order written by the Chief Justice at the time, Sue Bell Cobb, ordering the first 30% or whatever to be paid to district attorneys because they didn't have enough money to fund their offices. So as the growing crisis in court funding continued to grow, we actually undermine the fundamental mission of the criminal justice system, which is to punish defendants and make victims whole, and set aside the victim part, because we basically pitted the court system against victims to make sure that the court system was funded. So in some analysis out there, in court cost analysis, now we know that victims are actually paid last. So the language here is to make sure that in any question that comes up, when anybody tries to get around any prohibition about where court costs are supposed to go, that it is in fact our intent that when the defendant pays money to the court system, that the defendant's money goes to the victim before anything else.
Mr. Polder, I think you had a question.
Representative England, in theory, that makes sense to me. I mean, you say it's to, we punish them and make the victim whole. That makes sense. But I'm wondering about the case like that I had, where I represented a client who was owed restitution. A theft had occurred, and we're talking $50,000 to $100,000. That was the theft, and it was going to be a long road before that defendant was ever going to be able to pay that off. And so my issue is with what I see in this bill is you're not going to be collecting court cost. You may never collect court cost and fees, because if you've got a $100,000 theft and that's the restitution, and somebody's going to be paying that at $5 a month, but the court's just never going to get its court costs. Whereas I would think you could at least get court costs that the defendant would be able to pay that. Whereas a restitution amount could be so large, our courts are going to be operating without the money. So I guess that's my issue with.
So your argument is that we shouldn't pursue restitution because it could be too much?
Absolutely not. You should be pursuing restitution, but all you're doing, you're not talking about what we pursue and don't pursue.
No,
all you're doing is setting an order of payment.
The only purpose of this bill is to make sure that restitution is paid first. And I'm not sure what other mission that you could have in the course of a criminal prosecution than to do whatever it takes to make the victim whole.
You absolutely want to make the victim.
So again, I don't know if you want to argue that if we're pitting the funding of the court system versus the original mission of the court system to make the victim whole, that we got to make sure that the court system's taken care of.
But we can't make the defendant whole if we don't have a court system that's funded.
Well, that's not the victim's issue. That's actually the state of Alabama's issue in terms of funding the court system.
Well, you've got court cost, and what I'm saying is if you can't pay, I mean, somebody could probably pay court cost and get that done, but if we're waiting around for restitution, and that is the only thing, in theory, I love what you're talking about, but we can't just have not allow our courts to take in money that could have been paid, because I worry about the situation where the restitution is going to take years, but they could probably handle the court costs pretty quickly. But you getting like a $100,000 theft.
So again, your argument is victim wait around while they pay the court cost off.
No, victim can be getting money, but court cost and things like that are, I mean, I don't know what we're talking about here, what the fee would be for that. But I worry about the situation where you have $100,000 in restitution, and we don't have, maybe it's not paid for 30 years.
Welcome to the court system, because we wait for the court costs to be paid for about the same amount of time too. But if we're waiting for the defendant to pay something, I would much rather we be waiting for the defendant to pay restitution than to pay court costs.
Because I absolutely wanted my client, and they did, and I think they should be getting a portion as well. I'm not saying that your point about waiting to the very end, but what are we talking about in fees? Are we talking about like $400 or $500, and then we've got $100,000 in restitution? I mean, when I start seeing that, it doesn't seem practical to not go ahead and at least take court costs. So I don't know what kind of fees and costs we're talking about.
On average, if you're talking about a Class C felony, for example, there's a range of punishment. There's a fine on that. And right now, top of my head, I think it's $1,000 to $10,000 on a Class C felony. But we're only talking about the fines because there's also court costs. There's also victim's impact. There's also, depending on where you are, you could be paying for the American Village. Depending on where you are, you could be sending money to Boy Scouts of whatever county. It just depends. And right now, all of those entities get money before the victim does.
Yeah, and I understand your point about, but I guess it's, to me, doing a total reversal. To me, it seems like this ought to be scaled, and there ought to be some scaling here, because I do worry about a situation where you've got a large restitution amount. And
I'm going to ask you this question, though. Do you really want to get to the point where you say still as much as you can, because the more you get, the less likely we are to recover it? So, still a lot more? I mean, the thing I'm telling you is the whole point of the criminal justice system is not to prosecute people to fund it. The whole point of the criminal justice system is to prosecute people who commit crimes so we punish them and also make the victim whole. That's the whole point. Everything else is ancillary. So what you're really arguing isn't necessarily about how much restitution you're talking about. What you're really arguing is that the state of Alabama, as a state, doesn't adequately fund an equal, co-equal branch of government. So in a sense, what happens is when we reduce the amount of money that comes from the state, we increase the burden on user fees, and those user fees, that dollar that every defendant pays, now has to go to a whole bunch of different places. And unfortunately for us, over the last 15 years specifically, we've decided that the victim isn't as important as funding the court system. They're the last to get any compensation. So I don't know if we want to make it our argument that because the defendant stole so much money, that we want to make sure that the court system gets paid first, when the victim we're talking about got abused more than anybody else that we can imagine.
Well, that's where you're missing what I'm saying, though. I'm not saying 100%. That they get paid
what
first.
You're saying is, if somebody steals a whole bunch of money, right?
Right.
And $100,000.
Yeah.
But the court costs are $1,000. Let's take that $50 a month that the defendant is paying and give it to the court before we give it to the victim.
No. What I said is, I think there should be some kind of scaled system. I understand your point about not waiting to the very end, but I also think to just flip it the other way doesn't make a lot of sense either. You could have a scaled system where you're paying off court cost and you're starting to pay off restitution, and you could base it on the amount of the court cost and the amount of the restitution. I don't know where the magic is here. I get your point, but I also think to say that it has to be completely the reverse, that all the restitution has to be paid before you can get a court cost or a court fee, I think it feasibly and is not as practical, put it that way.
It should be. Because again, the mission of the court system when we prosecute people is to punish the defendant and make the victim as whole as we can through restitution. That's the whole purpose.
I appreciate it. Let's go. Mr. Brunier, you have a question.
Representative, I know that in my court, we have always had a policy of paying back restitution first.
Me too.
But that's because we're in a municipal court. We're talking the amounts that have been stolen or the damage that has been done that's being paid back is relatively small, but we already do that. We do restitution first and then court costs and everything after that. Have you spoken with the Chief Justice about this or talked with anyone about what the impact on our overall court system would be?
Oh, I imagine that every entity that depends on court costs are going to be impacted by this, including victims advocates will be impacted. Everybody will be.
Well, I know
but at the same time, yes, we've commissioned several court cost studies over the years to get to the root of, first and foremost, where the court cost is going, and also to try to figure out a way to retain more of the court costs, but also to figure out a way to get restitutions, to get victims any restitution, which rarely, unfortunately, happens these days in felony cases. So there has been some analysis of that, but as it stands, every year that goes by, victims are becoming less and less of a priority in this case.
I'm carrying a bill for the Chief Justice this time that's trying to reallocate some of their funds and loosen up the way that they can spend their funds from specified things previously to general court operations because they're in such a crunch. And my fear about this bill would be similar to what David's talking about, would be that it would put them in an even worse position. I know that there's, I think, level funding this time for the courts. That's leaving them at a $16 million shortfall. They're already talking about staff reductions and other things in the court system. I would be concerned about doing something else that might, and I don't know how much of an impact this would have, but it would have some impact on the funding of the courts right now when they're already in a pretty substantial situation.
But you see what this argument, what position we're taking in this argument, right?
Well,
we're putting the system above the reason that we're doing it.
Well, it's a practical look. Because
but again, what you're saying, practically, right? Practically, if the state of Alabama continues to reduce the amount of funding that goes to the court system, and the third co-equal branch of government is begging another branch for more money, then all we end up doing is incentivizing prosecutors and the court system to collect money more so than seek justice.
Well, I'm agreeing with you that it's unfortunate that the courts have such a tough time being funded. It seems like there's been a history of put the cost of the courts back on the criminals and on those that use it, in court cost. And so it's trying to be a pay-to-play court system where if you want to file a complaint, you got to pay the court cost. And if you're a defendant and you're going to have need of the court because of your crime, well, your fines and the court costs there is trying to fund the system instead of the citizens of the state at large funding the system, because as a co-equal branch of government, they would fund it. We have tried to just put it off on the courts themselves and on the victims and those that use it. On the defendants and those that use the court system. We need to have a better way. And I agree the victims need to be considered. We do that already in our little court. Mm-hmm. But as a practical measure, I think we need to know what impact this bill would have. Would it create any kind of really crisis if this were to go into place?
But again, I just have to point out the irony of saying that making sure victims are compensated would create a court cost funding crisis.
I don't want to have a crisis of our courts and then not be able to do anything for our people. Yep. So anyway, I like your bill in theory. I don't know how to do it practically that won't hurt the courts terribly. So,
and again, though, think about what you're saying. Compensating the victim, getting restitution will hurt the court system.
The system itself, yes.
That's tough.
Mr. Wadsworth, you had a question?
There's a perception out there now that every time tickets are given, it's all about the money. And we need to get back away from that and let it be for the victims out there. The vast majority of cases that are done, there is no restitution, and therefore all these cases that are they're paying on, it's going to go to the court system. But when people have bad checks, they don't want to wait 10 years to get paid. I had a case the other day where a guy had a bad check, and it was 10 years later before he got just the check amount back because he had to pay all these other stuff. But I'm for letting and I'm support your bill because I'm for letting us get back to the point of supporting the victims in this, because the vast majority of it is going to be no restitution anyway. And I support your bill.
All right, any other comments? Because we have a motion and a second for a favorable report. No. Ma'am? Yeah, we got it. All in favor of a favorable report, please say aye. Aye. Any opposed? Mr. England, you got a favorable report. Thank you, sir. Good job.
Thank you.
Mr. Tillman, you want to do 427?
Thank you, Mr. Chair. HB 427 is a consumer protection bill. Deals with what we call typically these dreaded spam calling. This bill right here is pretty much adding or amending our current code, which we have already law in the state of Alabama of do not call, but it has not been updated in the last 20 years. It only includes residential lines. So this bill would include cell phones as well as consumer lines, business lines, if so added. Also, this bill does a few other things, such as it will prohibit what we call spoof calling, the calls where people in the general area make a call and you may think it's a real number. So it may be if you're in Montgomery, 334 number, you may think it's a legitimate number, but it's actually a spoof caller. Also, the bill will prevent calls before 8 a.m. and after 8 p.m. And also, you can only contact a person within a 24-hour period 3 different times. And we also have penalties in it. The original code had $2,000. We moved it up to $20,000 because we need to actually make this a deterrent. So $20,000 was the price point of any type of violation. Also, this will be considered a deceptive trade practice. So we will have our Attorney General office as well as our local DA's office will have the ability to prosecute a person in violation of this. With that,
Mr. Chairman, I make a motion for a favorable report.
Second.
Okay. Yes, I'm so happy that Mr. Simpson is back.
I'll have y'all know, I didn't get involved in that argument with England that time. It wasn't me.
Thank you, committee.